She didn't come alone either, because Patricia had hired Daniel Berkowitz, one of the most expensive defense attorneys in the state, a man whose normal workload involved corporate fraud and federal investigations, not $200 speeding citations, and what unsettled me was not just the absurdity of paying $500 an hour to avoid a fine that most people would pay without protest, but everything that happened in the days after she was pulled over, phone calls to the mayor's office demanding the officer be disciplined, text messages to other wealthy parents about what she called over-policing, emails to the school board threatening to withdraw her children, murmurs of petitions to change school zone speed limits because they were inconvenient, and donations mentioned not as gifts but as reminders, bargaining chips wrapped in politeness, revealing a woman who didn't see the law as a boundary but as an obstacle that should move when she applied pressure, and when she entered my courtroom that morning she looked more dressed for a charity gala than a hearing, designer dress tailored perfectly, jewelry that glinted under the fluorescent lights, a handbag worth more than some family's monthly rent, while Berkowitz followed with a briefcase stuffed with motions that had no business in traffic court, and when I called the case he launched into a performance about radar calibration, signage placement, selective prosecution, using the solemn language of a homicide trial until I stopped him and reminded him that his client had been clocked at 65 miles per hour in a school zone, at which point he pivoted without blinking to claim that Mrs. Whitmore believed she was being targeted because of her social prominence. And I remember the silence that followed because it was the sound of a room realizing just how far removed from reality she was, and when I pointed out that most defendants simply pay their tickets while she had hired one of the most expensive attorneys in the state, she leaned forward and whispered urgently to him that this was about principle, as though that word had become a synonym for immunity. Then she stood up herself, bypassing counsel entirely, and began listing her credentials like achievements in a donor brochure: busy mother of 3, volunteer on multiple charity boards, woman whose responsibilities required what she called efficient time management, explaining that she believed the school zone hours were already over even though the citation time read 3:17 p.m. when dismissal ran until 3:30, admitting without embarrassment that she hadn't been paying attention to the time, the speed, or the children, and when I reminded her this was her 4th speeding ticket in 3 years she waved the others away as minor, then shifted her focus to the officer's alleged attitude, revealing the real wound here wasn't the ticket but the audacity of being treated like everyone else, finally saying out loud that people in her position were usually given warnings, and when I asked what position that was she answered plainly, without shame, that she meant people whose time was valuable, people who contributed, implying that other people's time, and perhaps their children's lives, were worth less. So I called Officer Thompson, a 12-year veteran who testified calmly that he clocked her Range Rover at 65 miles per hour during active dismissal, pulled her over 2 blocks from the school, and was immediately told she was late, then asked if he knew who she was, followed by a mention of her husband's donations, and as Patricia sprang to her feet to deny it the courtroom went still, because everyone present understood that this case had never been about a misunderstanding or a broken sign but about a worldview in which money wasn't a resource but a shield. "Whitmore, sit down," I said firmly, and then I turned to Officer Thompson and asked if the stop had been recorded, to which he answered calmly, "Yes, Your Honor, body camera," and when I instructed the bailiff to play it, the monitor flickered to life and filled the courtroom with the unfiltered truth, showing Officer Thompson approaching the Range Rover, the window sliding down, and Patricia Whitmore's face appearing, already irritated, already impatient, her first words sharp and dismissive as she said she didn't know why she'd been pulled over and that she was late for her daughter's piano lesson and needed to make this quick, and then the officer's voice, steady and professional, explaining that she had been traveling 65 miles per hour in an active school zone, prompting her immediate denial, calling it ridiculous and claiming she was barely over the limit, only for the officer to clarify that the limit in a school zone is 20 and that she was doing 65, and at that moment the video captured a subtle but unmistakable shift in her expression, irritation giving way to calculation, as she leaned forward and asked the question that has echoed through courtrooms for decades. "Do you know who I am?" followed by the officer's simple response that it didn't matter, and then Patricia identifying herself and her husband, emphasizing their status as major donors to the Police Benevolent Fund, their significant contributions to the city, and suggesting that a warning would be more appropriate, only to be met with the officer's request for her license and registration, which triggered her escalation, incredulous disbelief, references to how much her husband donates, questions about whether the officer understood their connections, demands for his badge number and supervisor's name, and accusations of harassment, all while Officer Thompson remained composed and respectful. And as the footage ended and the screen went dark, the silence in the courtroom was so heavy it felt physical. Patricia's face flushed red as she avoided my gaze, and I told her plainly that what we had just watched was not what she claimed in court, that she had threatened an officer's career for doing his job, tried to use donations as leverage, and then lied under oath about it, prompting her attorney to jump to his feet with an explanation about stress and emotional state, which I cut short by pointing out that his client had just committed perjury when she accused Officer Thompson of twisting her words, because the video showed he testified truthfully, and Patricia began to cry, apologizing and claiming embarrassment, insisting she had never been pulled over like that and didn't know what to say, to which I responded that embarrassment does not excuse lying, especially not in a courtroom, and when she claimed she simply remembered it differently, I reminded her the video was only 3 weeks old and that memory does not degrade that conveniently. Then I looked directly at her and asked if she had children, and when she answered yes, 3, and confirmed that 2 of them attended Hope Elementary, the same school zone she had raced through at 65 miles per hour, her sobbing intensified, and I asked her to imagine another parent doing the same thing and striking one of her children, asking whether she would want that parent to receive a warning because they donate money or to be held accountable, and through tears she whispered that she would want accountability, and I asked the obvious follow-up, why should she be different? And the silence that followed was the sound of entitlement finally cracking, and when I asked her directly whether she believed wealthy people should be treated differently when they break the law, she looked to her attorney, who shook his head, and she stammered that she didn't think she was better than anyone, that she just thought maybe there would be some consideration because of how much they contribute, which I immediately reframed as what it truly was, asking if she believed there should be consideration for endangering children, and she faltered, admitting she didn't know what she was thinking, apologizing again, but by then the issue had grown larger than a single traffic stop, because I wasn't finished, and I asked her whether she had contacted the mayor's office after receiving the citation, to which she hesitated and offered a carefully worded admission about expressing concerns over enforcement, and I pressed further, asking if she demanded Officer Thompson be disciplined, which she reframed as filing a complaint about how she was treated, and then I asked about the emails to the school board demanding changes to school zone speed limits, which she admitted were suggestions about the hours being unnecessarily restrictive, and I stated plainly that she had organized other parents to petition against school safety measures because slowing down was inconvenient for her, prompting her attorney to invoke the First Amendment, an argument I rejected by explaining that organizing a campaign to eliminate safety measures designed to protect children, including her own, was not protected civic engagement but reckless disregard on an institutional level. And when I produced documentation showing threats to withdraw her children and donations if the school board did not comply, she broke down completely, claiming she was upset and embarrassed and said things she didn't mean, insisting she would never actually endanger children, to which I responded that she already had, both by driving 65 through a school zone and by attempting to dismantle the very rules meant to prevent tragedy, and it was at that point, after observing not a momentary lapse but a pattern of dangerous, self-centered decision-making, that I made the decision that changed everything, instructing the bailiff to get the Rhode Island Department of Children, Youth, and Families on the phone immediately, causing Patricia's face to go white and her attorney to erupt in objections about appropriateness and overreach, which I overruled by explaining that her parenting was absolutely relevant when her conduct showed a willingness to endanger children for personal convenience, including her own, and when Patricia pleaded through sobs that I couldn't take her children, I clarified that I wasn't removing them but initiating an evaluation because a parent who drives recklessly through a school zone and then tries to erase safety measures raises legitimate concerns about judgment and priorities, and within minutes, Director Michelle Santos was on speakerphone as I summarized the situation, detailing the speed, the location, the subsequent campaign against school safety, and my concern about parental judgment, and Director Santos agreed that while removal was not being suggested, an evaluation was warranted, confirming that a file would be opened and a case worker assigned within 48 hours, and when the call ended, Patricia looked utterly shattered, her attorney furious, accusing me of abusing judicial authority, which I rejected by reminding him that judges have a duty to act when evidence suggests children's welfare may be compromised. And when Patricia finally found her voice again, begging and admitting her selfishness and stupidity while insisting she loved her children. She couldn't answer my question because she was crying too hard, the kind of deep, uncontrollable sobbing that comes when the last excuse finally collapses, and after the courtroom settled, I told her exactly what would happen next. She would accept full responsibility, pay the maximum fine, attend traffic safety school, and write a public letter of apology to every parent at Hope Elementary whose children she had endangered, to which she nodded desperately, whispering that she would do anything. But I made it clear that accountability does not stop at comfort, and when I ordered the bailiff to contact the Rhode Island Bar Association Ethics Committee, I watched the color drain from Daniel Berkowitz's face, then asked how much he had charged to defend a speeding ticket, and when he avoided the answer I turned to Patricia, who sobbed that she had paid $12,000, a figure that echoed through the courtroom as its own indictment, prompting Berkowitz to argue about complexity and expert analysis until I shut him down and told him that charging a small fortune to fight a school zone violation was exploitation, not advocacy, then explained the situation to the bar ethics director, who confirmed an investigation would be opened, after which I sentenced Patricia to a $500 fine, a 90-day license suspension, mandatory defensive driving school, public letters of apology to Hope Elementary parents, Officer Thompson, and the school board, and finally 100 hours of community service as a crossing guard at the very school whose safety rules she had tried to undermine, a sentence that stunned her until I explained that she would now spend her mornings and afternoons ensuring cars slowed down at the limits she once thought were beneath her, and when she objected that everyone would see her, I replied that visibility was the lesson, that perhaps other wealthy parents would think twice when they saw her holding the sign, and as something shifted in her expression from panic to understanding, she admitted aloud that she had endangered children, tried to use money to escape consequences, and believed she was special when she wasn't, and I told her that character, not wealth, defines a person, ordering Berkowitz to refund $11,000 of her fee or face deeper ethics consequences, after which he left in silence. And weeks later I received a handwritten letter from Patricia written during her second week as a crossing guard describing how every speeding car now made her think of the child she almost killed, recounting how a driver once asked if she knew who they were and how she answered that it didn't matter because children were crossing, realizing she had become the person she once tried to intimidate, and months later she approached me at a city council meeting to tell me she continued volunteering after her sentence ended, quietly funding safety programs without fanfare, confirming that Berkowitz had been suspended for exploitative billing and that DCYF found her home safe while recommending parenting classes she completed willingly, adding that her children were no longer embarrassed but proud to see her protecting their school, and in that moment I was reminded that while the law can punish, only humility can truly change people, because wealth without wisdom is just arrogance with a bank account, and no donation in the world buys exemption from the rules that keep children alive. Looking at Patricia Whitmore in that moment, I was reminded why traffic court exists at all, why we gather in small rooms with wooden benches and plastic flags and stacks of paper that seem insignificant until the wrong car passes the wrong child at the wrong time, because the rules don't exist to inconvenience the powerful but to protect the vulnerable, and no donation, no social standing, no outrage can undo the truth that driving 65 miles per hour through a school zone full of children is not an accident, not a technicality, not a moment of confusion. It is a choice made behind the wheel by someone who decided that their urgency outweighed everyone else's safety, and after 40 years on the bench I can say this with certainty. Entitlement is not loud, it is quiet, it dresses well, it hires expensive lawyers, It uses words like principle and contribution to disguise the simple belief that consequences are for other people, but every so often it walks into a courtroom, believing it is untouchable and learns, perhaps for the first time, that the law does not care who you are, only what you did.